Have you seen this crazy video going around on YouTube where the guy shoots the prankster? Well, we're going to break it down for you today. Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor. We are the partners of the Attorneys for Freedom Law Firm, here today to talk about a pretty interesting case, the YouTube prankster shooting video that's going around right now.
Andy, I can't remember a 30-second video that's got so much to talk about in it as this one here. This is really...
I think it's only like 20 seconds long.
It's a pretty short incident, so, people can watch it and make their own conclusions, but I think there's a lot packed into this 20 or 30-second video here.
Why don't we start by just watching it together?
Good idea.
Freshening our memories here.
All right, well... What?
Hey, quit thinking about my twinkle.
What's that mean?
Hey, quit thinking about my twinkle.
No.
Hey, quit thinking about my twinkle.
Get on my Facebook call Thompson. Stop.
Hey, quit thinking about my twinkle.
Stop!
Wow.
All right, so we have a DoorDash employee here who is picking up some food from a mall. And then the YouTube prankster's the gentleman with the white hat, and he is playing something on his phone. It sounds like kind of an obscenity that's a nonsense phrase, stop thinking about my twinkle or something like that. And he's simply kind of giving him a blank look and holding up the phone to his head and playing it over and over and over again. The guy tells him to stop a few times. The guy uses his hand to kind of swat the phone out of his, I guess you could say, personal space. The phone returns, and then he kind of starts walking after him, and he says, stop, stop, and then he pulls out his handgun and fires.
The food delivery guy, who is Mr. Colie, Alan Colie, he's the guy who gets charged.
The defendant in the case.
The defendant in the case. I sure like this case a lot. If he pushes the guy, if he punches the guy, clearly the prankster, whose name is Tanner Cook. This is absolutely a threatening situation. Right? There's no question about that. There are lots of little aspects here that I think are relevant to a self-defense case. So already you got an issue, right? There's at least two, maybe three against one person here. Plus, if you look at the prankster, Mr. Cook, he's significantly bigger than Mr. Colie, right? I mean, he's much taller. He's far heavier. Even if it was just one-on-one here, you have a huge mismatch. So those are all good factors for Mr. Colie in terms of exercising self-defense.
Well, let me throw one other one out, which is simply the behavior of the prankster here, right?
Absolutely.
He's got a kind of dead stare look on his face.
Yep.
He's acting completely irrationally.
Yep.
It looks to me, I mean, any reasonable person could look at that behavior and say, this guy is on drugs. This guy is suffering from, maybe he's even suffering from a mental health episode, but there's something not normal here. And if you see that, you're allowed to, the law allows you to kind of incorporate that into the totality of the circumstances.
Absolutely, yeah. And, we should have said maybe at the beginning, it's always a totality of the circumstances type of an analysis. So, you can tick through each one of these things. I think also the prankster, Mr. Cook, he sticks the phone in Mr. Colie's face. Okay, it's a phone, it's not a firearm, but, a phone can be used as a weapon as well. Mr. Colie clearly, he pushes the phone away at one point. He retreats. He's walking away. And Mr. Cook continues to pursue him. So all the aspects that you want for a self-defense case are clearly present.
It's definitely a threatening situation.
There's no question about that. If Colie pushes the guy, if he even punches the guy in the face, I don't think anybody who is involved in doing self-defense cases thinks there's a problem here. But that's a use of ordinary physical force. And so what complicates this case is that Mr. Colie pulls out his firearm right away and shoots the guy dead center.
Yeah, let's say a word about proportionality, right? Because just because somebody is putting you in a threatening situation, or even if they are blatantly an aggressor against you, the law only allows you, under self-defense law of every state in the country, to use proportionate amount of force. And this is, of course, the talking point of the prosecutor in this case, which is basically that he brought a gun, which is deadly physical force, to, at worst, an ordinary physical force situation.
Yeah, so the question here is going to be whether Mr. Colie subjectively believed and whether an objective, reasonable person in Mr. Colie's situation would have also reasonably believed that the threat to Mr. Colie was not just imminent, but either a threat of death or serious bodily injury. That's a little bit tougher of an argument, I think, to make, right? Because, when you first look at this video and you see Mr. Colie just right away pull out the gun and blast the guy dead center, your initial reaction is he used too much force. And, of course, we know what happens in this case, right? Mr. Colie, I don't think it was unreasonable to charge Mr. Colie here. He gets charged. He actually goes to trial. I think the actual charge in Virginia where this case happened is called malicious wounding. Other places might have called it aggravated assault or something along those lines. But he goes to trial and winds up with a public defender. And I think it's an interesting point to talk about that here as well. The public defender he had, his name is Adam Pouliard, I think is how you pronounce it. I actually had a conversation with him.
Yeah, and we're going to talk more about our conversation we had with Mr. Pouliard in a different video, so definitely check the link down below.
But, I gave him a call as a fellow criminal defense lawyer and basically said, hey, man, that was a nice piece of lawyering at trial. I think any criminal defense lawyer looks at this case and says, man, there's some things to talk about here for sure in terms of self-defense. But it's a tough argument because Colie just pulls out the firearm and blasts him. He doesn't pull out the firearm and say, hey, man, I got a gun. Leave me alone. Look at my gun.
A defensive display.
Yeah.
Holding it down at the ready, things like that.
Right. As criminal defense lawyers, we like to see sort of an escalation, right? Hey, man, leave me alone. I got a gun. Hey, man, look, I got a gun. Leave me alone. Hey, man, I'm pulling it out. I'm showing it to you. Leave me alone. Before just pulling out and blasting the guy.
Right.
So it looks like he escalates it a little bit quickly. But this public defender, Mr. Pouliard, does a really nice job at trial here because he gets the not guilty on the malicious wounding. There's some other points here, too. I think Mr. Colie, he repeatedly tells this guy, leave me alone, leave me alone. He's walking away. It's clearly threatening conduct. The prankster Cook continues to pursue, continues to come after him. And he's playing this weird message that
just nonsense, basically.
A nonsensical message, which kind of goes to your point. Maybe this guy's unstable. He's mentally ill. Some states have a duty to retreat if you can in complete safety. Virginia is one of those states that doesn't have a duty to retreat unless you contributed to the affray, which means
he clearly didn't contribute to the situation.
Right. He wasn't the aggressor here. I think there's no question about that.
He was literally targeted by a guy for a YouTube video.
Yeah, and so the question here really for the jury is, can the prosecutor show, beyond a reasonable doubt, that Mr. Colie used disproportionate force? He used too much force. And, there's a pretty strong argument for him on this case. I think it's important to note, by the way, that Mr. Pouliard, the public defender on the case, it's public information, by the way, that the prosecutor in this case filed a motion attempting to get into evidence at the trial the fact that Mr. Colie made a call immediately to the United States Concealed Carry Association. This is an interesting point. It's probably worth lingering on this for just a moment. I don't know whether that actually should come into evidence or not. USCCA is not a law firm. If he had called a licensed attorney to say, hey, I need advice, this and that, probably that does not come into evidence. I think most courts are going to say this is very prejudicial. It's not technically a communication between attorney and client. It's the fact of the phone call.
That he made the call.
Yeah, right. What was said on the call is clearly protected by attorney-client privilege, but the fact...
I'm confident that we could keep that out if a prosecutor tried to get it into a call to an attorney.
Yes, I feel pretty comfortable, but in this case, the call is to the USCCA. You're not calling a law firm. You're probably not even calling an attorney. It does raise the question, if this guy's a USCCA member, and, I spoke to the public defender about this. I asked him, I said, why are you on this case? I thought this guy was a USCCA member. He had the USCCA insurance for this very purpose. He told me personally, he said, look, I'm not really that familiar with USCCA, but I was curious about this myself, why they didn't provide an attorney. So I did some research, and I got on the USCCA website, and I looked at that, and what he told me was I saw an exclusion for criminal acts and figured this just doesn't cover criminal acts. So he said, I moved on. I didn't think about it. Now his client, Mr. Colie, is in jail at the time, and so sure, it didn't go any further than that, but I think it does raise a question for people who are members of USCCA. And again, we don't have any firsthand information about this because we haven't spoken to Mr. Colie. So I don't know the facts. All I can report is what his public defender told me. And what he said was, yes, Mr. Colie was indeed a USCCA member, and the USCCA decided not to cover this as a self-defense incident.
Very interesting. And like you said, we have very limited knowledge about this just from talking to the public defender. But maybe the internet will help us out here. And that's oftentimes what happens in these types of situations. We don't know. We have not spoken to Mr. Colie about this, but we have reason to believe, certainly from the filings that took place in court, that he was a USCCA member and ended up with a public defender.
There's no question about that. He ended up with a public defender.
Well, isn't it interesting that on a self-defense theory, that public defender was able to get him an acquittal on the biggest, most serious charge?
Yeah, this is the problem with trying to prejudge these things right at the beginning and decide, is this a legitimate act of self-defense? Is it a justified? It's very hard to tell. The other thing to talk about on this case is you just never know what a jury is going to do. I think if you show this video to 10 experienced criminal defense lawyers who do these kinds of cases, at least 9 and maybe 10 out of 10 are going to say, yeah, this guy used too much
Bad
force.
shoot, right.
Bad shoot. Yeah, and I'm sure that's probably what, if indeed USCCA looked at this, probably they looked at this and said, oh, bad shoot, we're not going to cover it. But, you just can never tell what a jury is going to do.
Yeah, that's the same thing they did to Colie Giles, right? And I see a lot of apologists for USCCA in the comments of review videos, some of ours, some of the other ones that kind of are lambasting USCCA for their, disclaiming coverage of Colie Giles. And they say things like, well, she researched on the internet how to kill your husband and how to get away with it and everything like that, and then she shot through the door. Well, okay, let's make it worse than that. Let's say that she had it all planned out and there was a step-by-step plan of how she was going to murder her husband and everything like that. You still don't lose your right to a defense.
That's right.
Even if you had it all planned out and everything like that, you may be still justified in shooting him, and you also might get a jury that wants to acquit you.
That's the key point. I tell people all the time, as you know, I speak on these issues quite frequently for almost the last 30 years, and I tell people a couple of important points. Number one, the question of whether or not it's a legitimate act of self-defense all comes down to reasonableness. I mean, it's just really at the end of the day, was it reasonable under these circumstances to do that? That's the question. And then the second thing is, who's making that determination?
Right.
It's a randomly selected group of people from the local community. You have no idea what they're actually going to think is reasonable. This one you look at and you say, oh, they're probably going to think this is unreasonable.
From an objective
Yes.
legal analysis, this doesn't look like valid self-defense.
But it turned out to be.
That's right, because there's a super important point
Okay.
here to flesh out
Okay.
about this exact issue, which is it's up to the jury what happens at the end of the day, right?
Yeah, that's a good
So there
point.
was this second charge, which is unlawfully discharging a firearm within a mall.
Yep.
Right, and he's ultimately convicted of that,
Yeah.
which, for reasons that we'll explain in a second, don't make a whole lot of legal sense if the jury did find that he acted in valid self-defense, which itself isn't clear, but let's table that issue for now. On the subject of the jury gets to do what they want at the end of the day, I saw a few news articles where 2 of the jurors in this case who acquitted him on the malicious wounding but convicted him of the unlawful discharge of a firearm in a mall were interviewed, and they were asked about these seemingly inconsistent verdicts. And one of the jurors told a news outlet, remember, these are folks off the street. They're not super sophisticated. They're not lawyers.
That's what you get.
One of the jurors told a news outlet, I know it seems weird, but, we were split. This split decision, as the juror called it, the split decision is what we all kind of came to in the jury room.
We call that a compromise verdict,
Right.
Some of them say, well, we want to give him a not guilty, and others say, well, we just don't want to let him off.
Yeah, we can't let him off with nothing.
We got to get him with something. So this discharging a firearm in a mall thing is out there. Let's go with that. Do we agree? Let's be unanimous on that and get out of here.
And this is the jury trying to do what they can to make the verdict most reflect what they think is a reasonable outcome, right?
This is why
Colie Giles' jury could have done that.
Absolutely.
Any jury can do
That's
that, no
right.
matter what the facts are.
That case could have gone, Colie Giles could have gone the other way. Virtually any case could go the other way. So you just really never know for sure. Look, I can tell you in my 30 years, I have won cases at trial where I've had some egg on my face, where I've told the client, look, you're being a fool to go to trial. look, I'll do it if you really want me to. It's your decision, but I think going to trial is a big mistake, and we've won. And I've thought to myself, oh, my God. And you talk to the jurors, and you hear the things they say, and it's like, okay. And then I've had other cases where I've tried them, and I've thought, we're definitely going to win this. And even the prosecutor's like, yeah, I'm definitely going to lose. And they come back with a guilty. And then you talk to them, and you're scratching your head because of the crazy things they're saying.
You see the crazy things that the jurors are interested
yes,
in.
and so I think, if there's a big takeaway, I think, from this case, for people who are listening to this video, only really people who try cases understand how fickle juries can be in cases. There are many cases you could try 10 times. You're going to get 5 not guilties and 5 guilties. You just never know. And as hard as we try to pick favorable jurors, it's very difficult, right? I mean, Andy, you've been there as I've picked juries. Raise your hand if you think the gun laws are too strict. And then you get all the gun guys raise their hand. Raise your hand if you think they're not strict enough. And you get all the people who hate guns raise their hand. And, okay, we try to weed them out, right? We talk to them. And you're left with the people kind of in the middle. And you're saying, who are these people? What is going on in their mind? Okay, they don't have felony convictions. They've served on a jury before. The guy works here or works there. We really don't get an awful lot of information. I mean...
Well, there's other dynamics. There's social dynamics,
That's right.
too.
Yeah.
We've thought that we had very good pro-gun jurors in some cases, but then when they got into the jury room, some anti-gun jurors kind of revealed for the first time that they were anti-gun, outnumbered them and kind of bullied them into switching their position. And we found that out afterwards when talking to jurors
It's
before.
very hard to tell. I know some criminal defense lawyers who say, oh, this guy was for guilty on a previous trial. I'm getting rid of him. And I said, well, how do you know? Maybe the guy's attitude is, I went guilty last time, and to show I'm fair and even-handed, maybe I'm inclined to come back with a not guilty this time.
To me, this seemingly inconsistent set of verdicts on the acquittal on the malicious wounding and the conviction for firing it inside of the mall reflects in the practical world a conversation that took place in that jury room that went something like this. We really don't like this prankster guy. He seems like a real jerk, a real troublemaker. We don't want to send a message that you can just go around and stick your phone in people's faces playing obscenities and everything. But he
See him pull out the gun and shoot the
probably
guy?
shouldn't have shot the guy. We don't want to get him with the most we can, but we should get him with something. That one's more serious than that one, right?
Yeah.
Let's acquit him on the serious one and convict him on the less serious one. That's almost literally, if I could guess, probably what happened in the jury
And if you're listening to this and you think that most jurors are more sophisticated than I think you're mistaken.
You are mistaken.
You're mistaken.
You are absolutely mistaken.
I mean,
As somebody who's spoken to many jurors after our trials, you are mistaken if you think the analysis is a whole lot more sophisticated. I want to go back to why this is an inconsistent, or at least seemingly legally inconsistent set of verdicts. So if the jury did, in fact, find that he acted in valid self-defense with regard to the malicious wounding, well, then by definition, that is a lawful shooting. That's right. And so he's convicted on the other count of an unlawful discharge in a mall. Well, if it was a valid act of self-defense, it is by definition a lawful shooting. He was allowed to, even though they don't usually allow you to discharge a gun inside of a mall, if you are doing so in a valid act of self-defense, the law makes it a lawful shooting. So as his attorneys recently argued in a motion to overturn that conviction for apparent legal inconsistency, this doesn't make any sense.
Yeah, I spoke to the public defender about this, Mr. Poliard, and right before his argument, I think it was a day or so before his argument is when we spoke, which ultimately he lost, right? Because we know the judge rejected this argument, and he felt pretty confident, as did I, that this other charge would be thrown out. Now, there's probably some wiggle room here, and we really don't have the benefit of the details of the jury verdicts, right? Because I think it probably turns on if the jury verdict reflects a not guilty as a result of self-defense, then I agree with you here. It's a lawful act. If it's just not guilty, and we don't know why.
And we don't know why.
We assume it was a self-defense, but there could be other reasons why a jury might have said not guilty. And if there's a reason other than self-defense, okay, there's a little bit of wiggle room there for the judge to reject this argument and say, well, you know.
And of course, this is exactly what the prosecutor argued in their opposition to the motion to overturn the verdict. They said, well, you know, who knows if they found that it was valid self-defense? They might have acquitted him on something else, even though...
It's hard to imagine.
Even though, to my knowledge, there were no other defenses offered by the defense other than self-defense. I could be wrong on that, but I'm almost certain that's the case.
Maybe it could be a mental state issue, right? I guess I could envision Mr. Colie maybe has some kind of a mental health issue. Maybe there's an insanity kind of a defense here. Then,
if they found that, it wasn't based on anything presented by the defense. It was their own machinations that they came up with in the jury.
Yeah, maybe they concluded this guy's not competent or something. And maybe the other charge, which I'm not familiar with, could be a strict liability type of a charge, which means it doesn't matter what his mental state is. If you discharge him all, you're guilty of this offense. I don't know. And we don't have enough detail as we sit here to know exactly what jury instructions were given, what those verdict forms say. And so we really can't answer that question. All we know is there's a good appellate issue here right now.
Yeah. I mean, there's so many morals to be taken here. And I think there should be a moment here to reflect upon how important it is to be entitled to defense and to be presumed innocent and to allow the process to go underway and defend yourself and put it before a jury. I think all of the Kayla Giles apologists, right, or I should say the USCCA apologists out there who say, well, you know, in a situation like Kayla Giles, it was so obvious that she was guilty. I'll bet a lot of those people watch a video like this and are happy and feel like justice was done with the acquittal on the malicious wounding. I'll bet those people are like, yeah. And so to those people, I would say, don't be so quick to just write somebody off, because just as lawyers who've done many, many, many self-defense cases and many other lawyers who do self-defenses will probably tell you, that doesn't look like valid, legal, proportionate self-defense. But if you're still happy with the outcome here, then you should be less quick to judge other people who might be in similar situations. Maybe there's a more reasonable outcome that the jury might tailor in their pursuit to get a reasonable verdict, right?
Yeah, and at the end of the day, this is a really interesting one. And like I said at the beginning, there's a lot to talk about here. I hope people look at this very carefully, and especially people who are in these programs that sort of exclude bad shoots. They exclude, and it's got to be a lawful act of self-defense. This is an easy one to look at as one of those other companies, just like it appears USCCA did here, and say, oh, no, this is not a legitimate act of self-defense. We're not going to cover it. And it just turns out, if that is what happened, boy, if I'm over at USCCA right now, I'm thinking, wow, we made a big mistake, right?
Big time.
Big time mistake.
This would be the equivalent as if Kayla Giles' lawyer won her case on the self-defense.
Yes, this would be the equivalent of that, because most of those people are going to look at this and say, clearly bad shoot, I think, as well. So if your position is that USCCA properly declined coverage in the Kayla Giles matter. And as we said in that one, look, we weren't that acquainted with the facts, but we did speak with her attorney, the one that was paid $50,000 by the USCCA, and he told us he thought this was a defensible case. Okay, it didn't go that way at the end with, I think, the public defender that she had. This is just more evidence that you really can't prejudge this stuff at the beginning.
I'm really interested to see if this guy he apparently was a USCCA member. I mean, you would assume that. I mean, it's possible he wasn't a member and was calling them, just to get help or something. But assuming he was a member, and assuming he called them, and assuming he was denied coverage because they determined that this was not self-defense.
Right in your time of need. Right in the one time probably in your entire life that you're going to need emergency services there, you were denied.
Like, just from a PR perspective, if that's true, just from a PR perspective, especially in the wake of the Kayla Giles thing, they might have just opted to take the case regardless, right? Just to avoid the bad press. But
incidentally, this thing comes into our office. If he's an AOR member, we're excited about this case.
Absolutely.
This case,
even if he wasn't allowed to own the gun,
right, we don't
even
care.
If he was in a sensitive place.
Right, he's a prohibited possessor.
With a sawed-off.
An illegal weapon. And he's drunk.
Yeah.
We're still happy to defend the guy under AOR. Yeah, no problem. And you know what?
It's good being a criminal defense attorney, and we don't have to hide behind all the exclusions.
Yeah. So anyways, this is a very interesting one. I hope we can get Mr. Colie to talk about this case. Now that his other charge didn't get thrown out, it looks like he's on his way to an appeal, which of course raises another question.
Well, he's got a sentencing set in December.
That's right, and then probably an appeal after that.
Yeah, I'll say something quickly about that. I mean, in Arizona, for example, where our law firm is situated, We've done a whole bunch of unlawful discharge cases, and these, especially for somebody who doesn't have criminal priors, which I understand Mr. Colie does not, aren't the type of thing that you go to prison for a long time for, if at all. Most of these things end up in some sort of probation deal, so I don't know exactly what he's looking at here, but no doubt it'll be significantly less time, or maybe even time served, given that he's been in custody for a while. Certainly less than what he was looking at.
One other little last passing thought that just crosses my mind here. Imagine USCCA or one of these other companies does cover this, right? And gets the same result here that this guy got. You got a criminal offense at the end, discharging in a mall. How can they cover the appeal?
Oh, geez.
Because they've already said if you are convicted, right, you plead guilty. In fact, we've played the Tom Grieve. Maybe we'll put it in on this video. I don't know. But we've played the USCCA video with attorney Tom Grieve, who I have some respect for, by the way. I think he's probably a very good lawyer. Came out very honestly and said, look, if you plead guilty or you're found guilty, all coverage ends.
Coverage stops in the event of a conviction.
Well, does that include your appellate coverage?
Right. So all of the insurance-based self-defense programs proudly tout that they cover appeals.
Criminal appeals.
Criminal appeals.
How do you get to a criminal appeal?
It is impossible if you're convicted. They have to disclaim coverage at that point. It is illegal to insure an illegal act.
If you're going to say at the same time, we cover your criminal appeal and all coverage ends if you are found guilty or you plead guilty, it seems to me you're saying inconsistent things right there. So
Absolutely.
I like that this video came up. It gave us an opportunity to talk about lots of different questions. We could probably talk about this video and the issues we brought up here for the next 3 hours.
Wow, we really did have a lot to say about that 20 seconds of footage. You weren't kidding, Mark.
I
But
know.
hopefully we weren't too long-winded. This has been attorney Andy Marcantel and attorney Marc J. Victor. If you liked this video, make sure to like and subscribe it. Maybe share it with a friend. Go check out attorneysonretainer.us to learn more about our program. Or you can go to attorneysforfreedom.com, learn about the law firm. And until next time, my friends, this has been attorney Andy Marcantel and attorney Marc J. Victor.
Peace.